Good morning. I'm Jane Fielding. I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK, and I'm delighted to welcome you to the first in our series of webinars for our mid-year review of where things are in the world of employment law. When we were planning these events, we were considering going back to having them in person, but now, of course, with the rail and the tube strikes in London today, we're very much patting ourselves on the back that we decided to stick with webinars this time round. So our topic today for the first webinar is TUPE, and specifically changing terms and benefits in a TUPE context. What we find when we're advising clients is that even those who work regularly with TUPE and are very experienced in it still find this a frequent challenge. So we thought it would be a good topic to focus on today. And our speaker is Hannah Swindle, one of our principal associates and senior lawyers in the team, who has a particular specialism in TUPE. So she's very well placed to talk you through this topic today. She's going to spend about 25 minutes doing that, and then we will have 10 minutes at the end for questions before we finish the webinar at 11:45. And it's my job to field the questions as they come in, so we can take them at the end and also make sure that we do finish on time. If you want to ask a question, please can you use the Q&A function, which you'll find on your Zoom screen in the middle at the bottom. We may not have time to get to all of the questions, but if you ask a question with your name attached, we promise to come back to you by email afterwards, so you will get an answer at some point. If you have any technical issues, hopefully you won't, but if you do, please also use that Q&A function, and Susie Barnes, who's our technical support today, will do her best to sort you out and get you back on track. And at the end, I will flag it again at the end, but just to mention, we will circulate a short questionnaire by email for anybody who's attended. We would very much welcome your feedback. We do take it into account when we shape future sessions. So if you have 2 minutes, we'd very much appreciate you taking that time for us. So I will now go on mute and hand over to Hannah.
Thank you, Jane. Good morning, everyone. We make a start. So the aim of an incoming employer in a TUPE transfer is usually to ensure a smooth and successful integration of transferring employees under TUPE. As employees transfer on their existing terms and working conditions, this can give rise to problems if the new employer is inheriting employees with terms that are significantly different to those of their existing employees. It's quite common for the new employer to want to harmonise those terms and working conditions with its existing workforce. It might be for ease of HR administration or to prevent perceived unfairness, which can impact employee relations or result in equal pay issues. They may also need to change existing working patterns to fit into how they run their business, or it just may not be possible to replicate current benefit terms. TUPE gives employees additional protections which introduce extra layers of complexity for employers wanting to make changes, on top of the usual limitations that there are already around changing terms. This can make achieving a smooth integration more difficult and result in risk. So today, I'm going to recap on the protections TUPE gives, discuss the types of risks that can result from making changes, and then I'll look at some practical ways to help mitigate that risk. I have a couple of quick quiz questions partway through for everyone to take part in. And as Jane says, we'll take some questions at the end. Before I make a start, I also want to mention that the same principles apply to both a business transfer or transfer of undertaking and a service provision change type of TUPE transfer. I also want to mention that in the context of insolvency, there are some relaxation of the rules, but we're not going to be covering those today. So as a quick recap, under TUPE, the incoming employer will inherit transferring employees on all of their existing express and implied terms and conditions, working conditions, which include employer policies and procedures, and with all contractual and discretionary benefits. To be able to work out if any changes are needed, a new employer first needs to know what those transferring terms are, and ideally as early as possible before the transfer. Sometimes full employee information will be provided by the client in an outsourcing tender process, especially where the outgoing employer is contractually required to give a full suite of employee information at an early stage before the transfer. Otherwise, an incoming employer is going to have to rely on the minimum protections under TUPE. Under Regulation 11, the outgoing employer is required to provide employee liability information 28 days before the transfer. And as part of this, employers have to give the particulars of employment that need to be provided, required by Section 1 Employment Rights Act 1996, and also information about relevant collective agreements. It's not a comprehensive set of information by any means, and 28 days before the transfer is often too little, too late, but it's better than nothing. If we've got contractual terms, these are protected by TUPE, which I'll go on to in the next slide. If they're discretionary terms, the incoming employer has the same flexibility to make any changes that the outgoing employer would have been able to make. But it's still important to consider employee relations issues when making any changes. And making any changes without consultation can create risk. A discretionary term can also become an implied contractual term through customer practice. So before changing anything, you need to make sure you've looked at all the relevant factors carefully. So I next want to remind everyone of what the protections are under TUPE. Any variation to a transferring employee's contract is void where the sole or principal reason for the change is the transfer, unless certain specific circumstances apply. Bayes guidance suggests that this actually means any reason connected to or related to the transfer, so that's slightly wider than it first appears. This all means that harmonisation in itself to bring the terms of the transferring employees in line with an existing workforce is not allowed, even if the employees agree to the changes. But there are some limited circumstances where transfer-related changes are permitted, and I've put those on the slide. So the first reason that changes can be validly made if the sole or principal reason for the change is an economic, technical, or organisational reason, or ETO reason, which entails changes in the workforce and the employees agree. To give a couple of examples that Bayes guidance have given us, an economic reason might be where changes are being made to increase profitability. A technical reason might be where the employer wants to use a different method of production. And an organisational reason might be where the management structure, for example, needs to change. Importantly, if an employer has an ETO reason, this also has to entail changes in the workforce. And in summary, this means changes in job function or numbers of employees, or a change in workplace. So the scope for an incoming employer to be able to rely on even a genuine ETO reason in order to make a valid change may actually be quite limited unless you've got that larger workforce reorganisation. It's going to be very fact specific, and it's still difficult to have any certainty about whether the changes will be valid if challenged in the future, as I'll expand on a bit later. Changes can also be validly made where the employment contract allows them. This means that the new employer can rely on existing contractual terms to make unilateral variations. For example, you might have a mobility clause allowing a change in work location. Not without its pitfalls, as would be faced by any employer seeking to rely on a flexibility clause to push through changes. It must be exercised reasonably. And in a TUPE transfer, employees also have added protection under regulations 4.9 and 4.11 of TUPE, which protect them where detrimental changes to their working conditions are being proposed. And I'll go through this later. Just to flag, these special protections don't apply to any changes unconnected with the transfer. But if this is the case, then the usual rules around changing terms for an employee still apply, so don't forget about that. By way of an example, we've got a case of enterprise managed services and dance. In that case, the EAT decided that post-transfer changes that had been made to the terms and conditions of transferring employees were not transfer related. They decided they'd be made as part of a wider reorganisation process. And the reason for this is because those changes reflected successful pre-transfer changes which the employer had made to terms and conditions of the existing employees, and they'd made those to improve productivity. But just as a note of caution, all the case law around changing terms and conditions is very fact specific, so it is really difficult to rely on previous case decisions to justify your own changes. Clients often ask when the protections under TUPE run out. The short answer is that in the UK they don't, although they do run out in some of the European jurisdictions. The passage of time by itself is not enough to mean that changes made will be valid. The key question is the reason for making them. Variations that took place several years after the relevant transfers have been held to be void because they were still made for a reason connected with the transfer. But practically, the longer the time period passes, the more likely it is that an employer will be able to argue successfully that the transfer is not the sole or principal reason for the change. I've mentioned that a new employer may need to make changes because they can't provide the same benefits to transferring employees as those they currently have pre-transfer. For example, an employee may take part in an employer's share option scheme or staff discount scheme, and it's linked to the outgoing employer's business. So it's just not going to be possible for a transferee to provide this in the same way after the transfer. If an arrangement is non-contractual, there's no obligation on the new employer to provide the same arrangement for transferring employees. However, even if an arrangement is stated to be non-contractual, it may have employee relations issues if it's just removed, or again, it might have become an implied contractual term by its regular use over a long period of time. So this does need to be considered carefully. If a benefit is a contractual right for transferring employees, it's a little more complicated to change it because of the TUPE protections around varying terms. In the case of Mighty Managed Services and French, the EAT decided that the transferring employees did not have the right to participate post-transfer in a contractual share scheme provided by the outgoing employer, which was Sainsbury's. Instead, they were entitled to participate in a scheme of substantial equivalence that was free from unjust, absurd, or impossible features. So although this does give a solution for any incoming employer, it does cause its own problems because it's not clear how we're actually going to measure equivalence. Practically, it's going to require discussion and consultation with transferring employees, ideally early before the transfer. And if it's not going to be possible to set up an equivalent scheme, the only other real option is to buy out those employees' rights. And I'll talk more about the options for making changes in a moment. There are also important non-legal considerations in changing benefits, whether contractual or discretionary. They may be an important part of the transferring employees' benefits packages, so the employer needs to always consider carefully how changing benefits will affect employee relations and how to make sure employees are reassured that the substituted benefits are in fact equivalent. So I now want to mention collective agreements. Any term in a collective agreement that's not incorporated into an individual employment contract, and so it's not enforceable, can be varied by the new employer, although they still have to approach this really carefully to avoid antagonising the unions or employees affected. Where terms have been incorporated into an employment contract, any changes that the employer wants to make will be subject to the same additional restrictions under TUPE, but TUPE does contain a special carve-out for collective agreements. A new employer can make valid changes to any individual terms in a contract which have come from a collective agreement, provided they take effect more than a year after the transfer, and also any variations must be no less favourable than the employee's previous terms when they're all considered together as a package. This all sounds helpful, but in fact, we haven't got any guidance as to whether this is a subjective or objective measure, so it's all very ambiguous, could lead to challenge later on if it's relied on. Also, please remember that any changes will need union agreement, so that could be an added blocker if they don't want to cooperate. Okay, so we now have a quick poll. Make sure this is all crystal clear. You should see a pop-up box come up on your screen. So the question I would like you to answer, please, which of these is not a valid reason for changing terms and conditions post-transfer? The first one, the contract allows the change. Number two, the change is needed to bring the business in line with industry norms and the employees agree. Or number three, the reason for the change is a relocation. Well, moving around quite a lot. Coming to an end. I think we're settling on number two potentially. Right, so yes, we have a majority going for number 2. The results should be on the screen there, so you can see. I have to say that the correct answer is number 3. It's slightly sneaky because a relocation could be a valid reason for a change, because after the changes made to TUPE in 2014, a change in workplace location can be classed as an ETO reason. But the point here is that the employees haven't agreed, which is also a key requirement for valid changes. So I think everyone's got that. Number 1, changes can be made by TUPE if they're permitted by the contract. So that was the mobility clause, the flexibility clause I was talking about. The second example is intended to describe changes unconnected with TUPE, because it's something that is responding to something outside the transfer. Okay, so if we move on, I now want to have a look at the risks, and we'll then look at some of the ways of mitigating risk. So I want to remind everyone in a bit more detail as to why this all matters. I'll flag out where risks can arise, because this can all lead to unwanted cost and hassle. First of all, any change that is not validly made under TUPE will be void, even if the employee agrees to it. So this means that the employer is not necessarily going to know if they've made a valid and enforceable change until it's challenged, and any challenge could be many years later. Often issues around changes would be raised in the context of an entirely unrelated dispute. For example, if an employee's raised a grievance about being treated unfairly. Certain changes will only impact on termination of employment, so can only realistically be tested then. So we might have changes made to restricted covenants or removal of enhanced redundancy pay. So this all results in uncertainty for the employer. It might not matter if changes are only minor or if there's not going to be any financial loss for the employee. But if the change does involve potential financial loss, this could be a big problem. For example, where something like holiday entitlement or overtime has been removed, the losses that could be claimed would add up, resulting in potentially a large breach of contract or unlawful deduction of wages claim. And that's going to be a problem, especially if you've got a large number of employees affected. Often the need for the ETO to entail workforce changes as well can also be problematic, even if you've got a good ETO reason. It's often not commercially practical or desirable to make those wider changes to the workforce. And if you try and create them artificially, it could mean that employees will be more unsettled and could cause greater employee relations issues. Finally, a term you may have heard of is cherry picking. Sometimes an employer will make changes by giving the employee a new overall package of terms. Some are beneficial, some are detrimental. A helpful case for employees is Regent Security Services and Power. And in this case, the EAT confirmed that employees can, in effect, cherry pick from the package after the transfer. They can choose to keep any additional rights they've been given, but any detrimental changes are unenforceable. So this could all leave employers out of pocket. We now need to balance this against the EAT's decision in a later case, which is Ferguson and Astrea Asset Management. And this case said that even beneficial changes are still void if not validly changed under TUPE. But a note of caution, this was a very particular case, I think turning on its own specific circumstances, because it involved executives changing their own contracts more favourably pre-transfer. But I think it's likely to say that that tribunals are still going to seek to protect employees. So employers should still be aware of the risk of cherry picking, but I think it's clear that the two decisions have resulted in more uncertainty, not less. There's also a risk that if employees don't like proposed changes, they can resign and bring a claim against the employer under the protections given by Regulation 4.9 or 4.11 of TUPE. Employees have the right to claim that the change is substantial and to their material detriment, or that it would constitute a fundamental breach of contract. TUPE gives the employees additional protection, so the resignation here would be treated as a dismissal, and the employees can claim it was either wrongful or unfair, depending on the particular protection they use. Case law has confirmed that a substantial change is going to be a question of fact and degree in the circumstances, And what is a material detriment is something that is more than minor or trivial. But this is all subjective, so the employee's view is really important. Cases on these protections often involve a change in location that might be required post-transfer, so to the new employer's workplace. Even a few miles can make a large difference to a commute time, and that can be a big problem for those doing school drop-offs, for example. It's often not clear-cut where liability for any pre-transfer resignations and claims under these provisions will rest, with the incoming or the outgoing employer. It's a bit of a legal grey area. And usually it's going to depend on whether the employee opts out of the transfer at the same time. But the outgoing employer is not going to want to be responsible for any claims arising out of the changes proposed by the new employer. So any sale or outsourcing agreement will usually include a suitable indemnity to deal with this risk. Importantly, something to remember, the protection under Regulation 4.9 for a change in working conditions can still apply even if the employer is validly relying on a flexibility clause in a contract, or if it's making a change to a discretionary and non-contractual term. So next, as another reminder, a proposed change to terms and conditions of employment or working conditions will be a measure for the purposes of the information and consultation requirements of TUPE. The incoming employer is required by TUPE to provide details of all measures that they're proposing, so the outgoing employer can include them in the consultation process. There's no statutory definition of what is a measure. It's given a really wide interpretation. It covers any action, step, or arrangement. It doesn't just have to be a contractual change. So it's important not to forget about any changes that the new employer intends to make to the employer's policies or procedures or discretionary terms. Even if the employer is permitted to change them, you've still got to tell employees because they're going to be measures. There's an incentive to do this process right. The penalty for a failure to inform and consult is potentially 13 weeks pay. So that's a quarter of the wage bill if you get it entirely wrong. It's also important for employee relations purposes. And as the new employer, it's important to try and make sure that you get off on the right foot with the employees. Although the main duty to consult is that of the outgoing employer, they'll usually look to bring in the new employer to any claim that's been made if it's been caused by a failure to provide that measures information. So we now have another poll. So again, you should get a pop-up box on your screen. And the question we are looking at, which of these is not an option for an employee if the transferee proposes making detrimental changes to pay post-transfer? Number 1, transfer and then bring a claim for unlawful deduction of wages. Number 2, resign before the transfer and claim wrongful or unfair dismissal. Transfer and then refuse to work unless the claim for original pay terms is honoured. So we'll just see where we're coming down. The results, I think we've nearly got them all. Okay, yep, that's looking quite conclusive at the moment. See if we've got a few more. Great. Okay, absolutely right. Yep, we've got the majority coming down on number 3, which is the correct answer. The employee cannot refuse to work even if they don't like the changes. Otherwise, they're going to be in breach of contract, and that may result in disciplinary action. The employer would be entitled to take that. The employee could choose to transfer and afterwards bring a claim for the deduction of wages. That is an option. They could also bring a breach of contract claim. But if they're still employed, this has got to be in the civil courts because they can only bring a breach of contract claim in the tribunal after termination of employment, so they'd have to resign at the same time. Alternatively, the employee could also choose to resign before the transfer under those Regulation 4.9 and 4.11 protections I've mentioned, claiming that these were substantial changes to their material detriment or a repudiatory breach of contract. Okay, so if we now move on to the mitigation options, how can you handle this in practice? Well, the first option, it might be possible to argue that any changes you want to make are unconnected with the transfer. If changes don't need to be made on day one, it might be possible to link any changes to an individual's later promotion or change in job role, for example. Otherwise, this might also work if you have a global reorganisation of the workforce and the proposed changes affect both the transferring employee population and the existing employees. If the changes are only going to affect the transferring employees, it may be possible for the employer to rely on an ETO if the new employer's got that genuine economic, technical or organisational reason, which importantly also entails changes in the workforce. So there might be a restructuring or redundancy process at the same time as a need to change working hours to bring all employees onto the same shift pattern, possibly. I've already highlighted the potential problems with this option. There's no certainty that a tribunal would enforce the change until that claim's brought, maybe much later down the line. But if the changes are minor or don't involve potential financial risk for the employee, the employer may be willing to take this risk. So another option, if the employer is only making changes that will be beneficial for employees, then practically they won't really need to worry about enforceability. I've mentioned that just because the terms are beneficial, it won't mean that they are necessarily enforceable. But in reality, if the changes are definitely positive, maybe a pay rise or an introduction of an additional new benefit, then employees are clearly not going to challenge these at a later date. Difficulties could arise where a change is made that looks beneficial, but a particular employee doesn't see it as such because of their own circumstances. So maybe the new employer is offering a new private medical scheme, insurance scheme, which gives greater benefits overall, but an employee might not see it as beneficial if they can't personally take advantage of it. So for example, if they've got a pre-existing condition. If employers are putting together a package of changes, employees may not be so likely to challenge individual terms later. But of course, it's still open for them to cherry pick the ones they want to keep. If employees are being given a new benefit in return for giving something else up, or a benefit's being bought out, that's not going to be enforceable if the employee wants to back out later. To reduce the risk, employees can be asked to enter into a clear contractual agreement that the new benefits or buyout are given on the condition that the entirety of the new package is accepted. And so if the employee then tries to go back to their old terms, they've got to repay any sums that they received or benefits given under the new terms. This is going to be quite difficult unless you've got a clear sum allocated to the new term. We've also not had any case law at the moment confirming that this approach would be enforceable. It's also necessary to be able to put back the old contract in its entirety, which often is just not going to be possible. Sometimes the employer needs more certainty around the change, and if so, one option is to dismiss employees and re-engage them on the new terms. So the employee is first dismissed and then offered new terms which are the same except for that element that's being changed. And this is also known as fire and rehire. Continuity of employment would be preserved. This is considered quite a heavy-handed approach. It can be expensive. It must be handled really carefully to reduce employee relations issues. And for non-TUPE changes, it's been highlighted recently in the press as being oppressive, and it's the subject of a new ACAS code. Importantly, it must be carried out under a settlement agreement. Otherwise, the dismissal will be automatically unfair as a result of other TUPE protections. And I also just wanted to flag here that my colleague Martin Chitty will be doing a webinar on fire and rehire on the 29th of June. I next wanted to mention settlement agreements because sometimes employers seek to make changes under a settlement agreement which the employee signs, but without making any dismissal. Importantly, this won't make any changes valid that would otherwise be void under TUPE. So you need to just be aware of that. It may presentationally look helpful, but it's not enforceable. The last point I want to mention on the slide there is contractual protection. If an incoming employer is making changes to working conditions in the context of an outsourcing, maybe because the client wants them to restructure and transform the service, they might be wanting to move to a 24/7 offering instead of a current 9 till 5 structure. If that's the case, the supplier may want to ask for contractual protection from the client to cover the risk of any Regulation 4.9 or 4.11 claims, because it's the client requiring the changes. So now for a few general practical tips. If the incoming employer needs to make any changes, they'll need to provide that measures information about them to the outgoing employer for the consultation process. It's usually helpful for the new employer to take a full part in the consultation process as much as they're allowed and speak directly to staff about their proposals. In this way, they can hopefully complete a much more effective selling exercise for the changes to the staff, get the staff's buy-in, which hopefully prevents more issues later. Individual meetings with employees may also be useful. So the incoming employer can talk to the employees directly, try to find out early on if there's going to be any issues with the proposed changes, and they can then try to head them off and iron them out early in order to avoid potential Regulation 4.9, 4.11 claims or other risks in claims after the transfer, such as discrimination issues. To try to gain goodwill with transferring staff, it's better to try to be as flexible as possible, to try to accommodate and work around any issues. Often it can be counterproductive to try to force changes through because employees often vote with their feet and they may bring a claim as well along the way. So finally, it's important to determine early what method is going to be used to make the changes because that is going to impact how long it may take. So that brings us on to timing. The timing of any change process is key. Can the new employer wait to deal with any changes until after the transfer, when it can then consult with staff in an orderly way once they've actually become their employer? Or is that not possible? Does it need to be made from day one? If a change is needed to be made to working patterns, it might be possible for the new employer to accommodate different patterns for a time after the transfer, which might enable a full assessment to be made of what they actually need. But often a business is not going to be set up to deal with different working patterns. And so if that's the case, they will need to change from day one. On the other hand, an employer might be able to make other types of changes over a period of time. So for example, ring fencing a company car benefit for a time post-transfer. If the employer has decided to dismiss and re-engage employees, this might trigger collective redundancy consultation obligations if there are 20 or more proposed dismissals within a period of 90 days. If this happens, there'll need to be 30 days or 45 if we've got 100 or more employees affected after the start of consultation before the first dismissal takes effect. And there are requirements about the information to be provided and the content of the consultation. If you don't do all of this, you're facing a protective award of potentially up to 90 days pay. Since 2014, collective consultation can be carried out pre-transfer, which can save time, but I query how much a new employer actually wants to do this if it can avoid doing so. It looks quite aggressive, and it might not necessarily start off on the right foot with your new employees. So in summary, the new employer needs to plan the change process carefully, decide what they need to change and how they're going to do it, and be really clear on the reasons why so they can explain these to staff. Where possible, they should try to be as flexible as they can to accommodate the transferring employees. So Jane, I think you've been monitoring the questions for us. Please, can I ask you to share what we've had come in?
Sure, yeah, we've had quite a few. So I've tried to pick out the ones that will perhaps be of relevance to most people and then deal with those first. And if we can pick up some of the more specific ones, then we can. So the first one touches on your first poll, I think, actually, or one of the polls. It's where the incoming employer, so in an outsourcing situation, the new provider, want to change the workplace, but they don't actually need to lose anybody. So they need the number of people, they just need them in a different place, which may well be the case for cost savings or whatever it is. So the question is, can you, as an employer, validly change an employee's workplace in that situation under TUPE?
Thanks, Dave. Yes, that's a good question. So I've mentioned that a change in workplace is now an ETO after the 2014 changes were made to TUPE. Before then, an employer would have also had to make job losses or change job functions as well in order to make those changes validly, which seems an absolute nonsense if you don't actually need to lose anyone or make those additional changes. And it is going to cause a lot more disruption to employees. So now, post 2014, we don't need job losses to make valid changes if you're going to change the workplace. But you also do need the employee's consent. So that's an important thing to remember. And if you don't get the employee's consent, then you need to look at ways of dealing with that. But it is possible under TUPE for that to be a valid change.
Okay, thank you. The next one is about substantial equivalence. So obviously you took everybody through that being the test if you can't, as the new employer, provide exactly the same benefits. So the mighty case. The question is, well, what happens if you try to address that constructively and you try to put forward a benefit that you think is substantially equivalent and the employee just won't accept it? How does that actually get resolved?
Yeah, absolutely. I mean, this can be a real problem. Ultimately, it's only actually finally going to get resolved if the employee brings a claim in the tribunal, and they're claiming that any change that's basically been enforced on them is not valid. And the tribunal then has to decide whether the employer has passed the test or not and has met the correct threshold and it's substantially equivalent. Practically, employees are only going to bother to bring an individual claim if it's actually going to be worth something to them, if it's going to be worth a significant amount of money. Because usually, unless there's other problems, they're going to wish to remain on good terms with their employer, and bringing a claim often means you're not going to do that. Employees do always have the option of bringing that claim at a later date. So that's something to remember. You may have good relations now, but they may deteriorate later on due to other unrelated issues, and that may then lead to a claim at that time. Alternatively, if you've got a union involved, they might choose to bring a claim on behalf of their employees against the employer, even if it's a smaller issue. But if it affects a lot of employees, it may be collectively important, and they've got the resources to do that.
Sorry, the very environmentally friendly building we're in turned my lights off because I was obviously sitting still too much. I'm back now. Right, the next question, which I thought would be helpful for people, is about employee handbooks. So we quite often get asked, don't we, do we have to replicate the whole handbook? Can we just bring our own in so that everybody's on our own policies and procedures? So it's quite a broad question. So what happens if you have a handbook? And the example, I think someone's got something in mind clearly, is if you've got an employee who's subject to an existing disciplinary process that you're about to inherit, do you keep with the old one or do you switch to your own? So.
Yeah, I think sometimes handbooks get forgotten about because it's almost taken as read by the incoming employer that they're going to be using their own handbook. They don't want to be operating the outgoing employer's policies and procedures, and they might just not be set up. And often when issues arise, they're going to forget possibly, and they'll just use their own procedures. If the handbook is the incoming employee's handbook is discretionary, then the new employer can substitute their own policies in place of the existing employer. But it is important that you remember to provide details of those proposed changes as measures, as I flagged up in the consultation process. Don't forget about them, even though you think you're going to change it as a matter of course. And ideally, you'll also flag up any significant changes within the policies to the employees so that they're aware. You want to head off any potential issues that could arise later if, for example, the sickness policy is not as generous or something along those lines. If it's contractual, then the employer would need to consider ways that they can validly make those changes in the way I've spoken about today. So it's a bigger challenge, but it can be done. But any employee, transferring employee who's going through an existing process, and this does happen, especially when you've got a large amount of employees transferring. They might be going through a disciplinary process or maybe subject to a long-term sickness procedure. Then it might be appropriate for reasons of fairness to keep those employees on their existing procedure. I think to actually make a decision on this, you'd need to look at each individual set of circumstances, look at how different the policies are, check how it might affect the individual. But I think in most cases, you're probably going to want to continue those employees on the process in which they've started. So you'd need to make that clear when giving the measures that anyone who's subject to an existing procedure would be continuing on their existing employer's process.
Yep. Okay. We've got time just for a couple more. I can tell you now we're not going to get to all of them. So if we don't get to yours, we will follow up with you if you've asked it other than anonymously. There's one here which is a scenario we see quite often, particularly if there's in the private sector where things are happening at short notice. It's what tips do you have for planning to make changes as an incoming supplier? So you're transferee, but you won't have the employee information, which, as you mentioned earlier, Hannah, helps you kind of shape what measures you might need until very close to the transfer date. So you're in a competitive scenario and the process just doesn't allow for that information to be released earlier.
I think you just have to do the best that you can with what you've got. Some information will be provided. If you're in a bid process, often there's the ability to ask questions, to ask follow-up, make inquiries. There may be some information that can be provided on a sort of more general basis. I think at whatever time or stage you have the information, you just have to try and work through that as quickly as possible. I think the important thing is that at whatever stage you get the information, if you know you're going to be making measures, then there's an obligation right up to the date of transfer that you provide those to the outgoing employer so that they can be taken into account in the consultation process. If it's a situation where you really don't have any information, then it might be wise to try and implement as few changes as possible, if that's at all possible, or to provide some information about, for example, your pay dates that you're going to be implementing, even if you don't quite know what is coming across, so that you're just feeding something in. Ultimately, if you haven't had the information and you can't provide measures, then I think you'd have a good defence to any later claim that might arise. But you'd have to, from day one, really get on top of what these employees have got and try and, just talk to them and consult with them and make any changes necessary as soon as you could. Try and deal with that as smoothly as possible.
I suppose commercially, depending on the situation, it may be. I'm just trying to. We did a job a couple of years ago where the information it just varied wildly between saying it was going to be 10 people or 150, and so we built into the contract with the client a kind of a change mechanism depending on how many people actually came across. But that doesn't necessarily help you with the awards from individual claims, does it? But commercially, it might help you offset some.
Yeah, absolutely. Yeah, I've had a couple like that, and we've had a price adjustment mechanism taking into account a reconciliation. I mean, this often happens even when you've got information given to you, but it may not be accurate because of the outgoing employer is not very organised. So you have an adjustment mechanism. A reconciliation is done at a certain point post-transfer, and then the charges or pricing can be adjusted accordingly to take into account any additional benefits or costs that weren't expected. I think that does highlight it's really important to get contractual protections in place as much as you can, because your contract with either the seller or the client in an outsourcing is going to be where you get your protection, whether it's unexpected employee protection or trying to adjust the price like this.
Yeah, and very quickly, there's a question that says, if you're in a collective redundancy scenario and you get a challenge for failing to inform and consult under the redundancy legislation collectively, can you get an award for that, and also for failing to inform and consult under TUPE if you also get that wrong? And I think I'm right in saying technically the answer is yes, but we don't see it happen very often in practice, do we?
No, I don't think I've come across a case where it has happened, but yes, it's definitely a risk. It's not excluded. There's no carve out, so you could theoretically be subject to both, and I think that's something to bear in mind. Yes,
could be a very expensive mistake.
Yeah.
Okay, that's all the questions we've got time for now. There are a few we didn't get to, so we'll follow up by email. But thank you very much, Hannah, for talking us through all of that. Thank you all for joining. As I said, you will get a questionnaire by email shortly after the webinar closes, and we'd be very grateful if you took the time to fill that in and send it back to us so we can use your feedback for future sessions. So, and just as a final reminder, tomorrow we've got our second webinar in this series, same time, 11 o'clock, and we're going to be taking a look at ESG, and it's a very common buzzword, but what exactly does it mean for the HR community and employment lawyers working in-house? So we have that tomorrow, and otherwise I wish you a very good rest of the day. Thank you.
Thank you, everyone.